Well, this is a real exciting time in terms of the evolution of the practice of law, and that affects courts just like it does practitioners and litigants. And so I'm here today hopefully to take back some wonderful concepts, ideas to other judges in the state, also to look at how we can improve programming within my own area of the world where I practice. Well, it is an exciting time in the judiciary now. We are going to e-filing, which is a new program that all courts across the state will be implementing. And of course, some judges are a little nervous about it. Others, I think, embrace it a little more. But hopefully it will create an efficiency, not only in terms of an access point for practitioners and litigants, but also will increase efficiencies for those of us on the bench who will utilize the paperless system as we preside over matters, for example. I think collaboration is vital as we look to be more integrative in terms of the justice system as a whole. It's very easy for a group of judges, for example, to sit and talk about difficulties, but if you don't bring in other stakeholders, you're really not testing the model that you're creating. So having a cross-section of stakeholders is vital in order to produce something that will be meaningful, useful, and most efficient for all involved. I think first of all it's important for law programs to offer clinical experiences, to mandate clinical experiences, or something like what MSU does here in terms of TPI, LegalRnD. Students should be encouraged, if not mandated, to complete one of those programs to make them a more well-rounded lawyer. I think too that we do need to really reassess how we're teaching. The Socratic method and the basics are of course very important, but that doesn't complete the lawyer. And so looking to what is actually going on in the legal community, both in the courtroom and outside the courtroom, problem solving, working with clients, those kinds of experiences need to be made available to students before they graduate so that they can hit the ground running. I think it's so important to be able to brainstorm and to work collectively. Something that I think our system has embraced previously that I think we're shedding is this idea that if something doesn't work the first time, we should abandon it and go back to the old way of doing business. I think that is no longer what the standard should be. And having opportunities to collaborate and to talk with cross sections, I think gives us the insight and the opportunity to really refine and create what we are ultimately desirous of creating. But having said that, if it doesn't work, we can learn from whatever that mistake is. It doesn't mean shut the door and it's a dead issue, but rather, okay, it's a challenge. How do we regroup and how do we achieve the outcome that we're ultimately looking for? And this environment fosters that process. I think that it is, again, a great time to be a lawyer, to be a judge, because I think we have a better appreciation for why it's important to make those connections, whether it be with our law schools, whether it be with our communities. For those individuals who perhaps aren't able to go back to their alma mater, they can utilize Twitter or other forms of social media to show that they are engaged, that they do care, and that they are that real person. I think that for the judiciary in particular, that sometimes we have faced the challenge of appearing to be unapproachable, and that is not the desire, and that certainly is not the mindset of most judges out there. And so utilizing technology, if you can't get back home, would be a great way to engage many components of the legal profession. Yes, social media usage is an ongoing discussion, certainly at the judiciary level and even at the state bar. And judges are being encouraged to not be afraid, but to embrace social media. And I think that if we adhere to certain standards, one can do that without falling into perhaps a rut. So setting guidelines for oneself, I am going to blog about X and I won't deviate from that, or myself as a national director for the National Association of Women Judges, when there are issues related to women judges, promoting other female judges, that's something that I can comfortably tweet about or blog about because I'm sticking to that particular topic. So I think that if there is guidance given, and we at the judicial level, the Michigan Judges Association, we have been on the forefront of educating our membership that they should not fear social media, that they should embrace it. And we are glad to receive the support of the Supreme Court from Justice McCormick, who is a blogger and a tweeter, and others in the judiciary. I think that we will see more people come around and feel more comfortable using that as a tool to communicate. I love specialty courts, and I think that specialty courts certainly fall within the structure that we are experiencing here today, that requires people to think outside the box, to come together, to problem solve, to be committed to a common goal. The system that we operate in is adversarial, and yet that doesn't mean that we can't have common goals and want to achieve common outcomes. And this is a thrilling way to experience it, and I'm looking forward to taking it back to our stakeholders. LegalRnD is phenomenal, and many students have made their mark thus far. Professor Lina's contributions here inspire students, and I have had some experience with several students at MSU who have a vigor and a vitality, and they have the sense of purpose, and they are unabashed in their commitment to the law and their commitment to doing things differently. And without this program, I don't know that we would have that spirit.